In 1908, a photographer named Lewis Hine was hired by the National Child Labor Committee to document working conditions in American industry. What he found over the next 8 years would become some of the most important documentary photographs in American history: a 5-year-old girl shucking oysters in a South Carolina cannery at 4 in the morning, a 7-year-old boy working a night shift in a Georgia cotton mill, 8-year-old coal breakers in Pennsylvania sitting hunched over conveyor belts for 10 hours a day, sorting coal with bare hands, breathing black dust, fingers permanently stained and often missing from the machinery. 12-year-old girls operating power looms in textile mills, standing on boxes to reach the machines because they were too short to operate them from the floor. Hine labeled each photograph with the child's name, age, and workplace. He had to use deception to get into many of the facilities, pretending to be a safety inspector or a Bible salesman, because the companies knew what he was doing and knew that the photographs would be used against them. He documented more than 5,000 children in the course of his work for the committee. None of what he documented was illegal under federal law. There was no federal law that set a minimum age for factory work, for mine work, for cannery work, or for any other form of industrial employment. Children could be hired at any age, worked for any number of hours, and exposed to any conditions their employers chose to subject them to, because the federal government had no authority to say otherwise. That authority did not exist until October 24, 1938, when President Franklin Roosevelt signed the Fair Labor Standards Act, establishing for the first time federal minimum age requirements for child labor. The 5-year-old girl in Hine's photograph of the South Carolina cannery could have been legally replaced the next day by another 5-year-old, under the law as it existed when he took the picture. This is the story of what child labor in America actually looked like before anyone was federally required to stop it. It is the story of the industries that preferred children because they were cheaper, because their small fingers could reach places adult hands could not, because they were less likely to organize, less likely to complain, and more easily intimidated than adult workers. It is the story of the 2 federal child labor laws that were struck down by the Supreme Court as unconstitutional, of the constitutional amendment that failed to ratify, and of the specific historical accident of the Great Depression that finally made federal child labor law politically achievable after 4 decades of failure. It is also, at the end, the story of what is happening to child labor in America right now, in 2025, because this history has not ended as cleanly as the textbooks suggest. To understand the scale of child labor in early 20th century America, you need numbers. In 1900, the census counted approximately 1.75 million children between the ages of 10 and 15 who were employed in industrial work. This number did not include the much larger number of children working in agriculture, which was not systematically counted and would have added several million more. It did not include children under 10, who were employed in some industries and not systematically counted at any age. The 1.75 million figure is a floor, not a ceiling. The industries that employed the largest numbers of children were textiles, coal mining, glass manufacturing, canning and food processing, tobacco, and street trades. Each of these industries used child labor in ways that were specific to the particular demands of the work, and each of these industries had developed arguments for why the particular form of child labor it employed was not as harmful as it appeared. The textile industry employed the largest number of child workers. Cotton mills in New England, and increasingly in the South, hired children from the age of 6 or 7 for a range of tasks that took advantage of their small size and nimble fingers. Spinners, who tended the machines that spun raw cotton into thread, had to move quickly between rows of machines, tying broken threads before the machinery could be damaged. Mill owners argued that this work required the quick reflexes and small hands that children possessed better than adults, which was partly true and entirely beside the point. The real reason textile mills employed children in large numbers was that children were paid far less than adults for the same work. A child spinner in a South Carolina mill in 1900 might earn 10 to 20 cents per day, against the 50 to 75 cents that an adult doing comparable work would earn. The savings were substantial, and in an industry where margins were thin and competition was intense, the cost advantage of child labor was a significant competitive factor. The mill towns of the South had been built around the labor of poor white families who had moved from subsistence farming to factory work in the decades after Reconstruction. These families came to the mills as units, with parents and children all expected to work, and the family wage that the mill paid assumed that the children's earnings were part of the household income. A family that refused to send its children to work risked losing its mill housing, its access to the company store, and ultimately its employment. This coercive structure was not unique to the textile industry. It was characteristic of the company town model that dominated many industrial communities in the late 19th and early 20th centuries. Workers who lived in company housing, bought from the company store, attended the company church, and sent their children to the company school were workers who had almost no practical power to resist company demands, including the demand that their children work. Coal mining employed children in a role that was distinctive to the industry, the breaker boy. Coal that was brought up from the mine was dumped into a series of chutes and conveyor belts in a structure called a breaker, where it was sorted and cleaned before being sent to market. The sorting was done by hand, removing slate and other impurities from the coal. This work was assigned to boys, typically between the ages of 8 and 14, who sat astride the chutes and picked through the moving coal with bare hands for 10 or more hours a day. The conditions in the breakers were genuinely terrible. The coal dust was thick enough to obscure vision across the room. The noise of the machinery was loud enough to cause permanent hearing damage. The coal was sharp enough to cut the fingers, and breaker boys' hands were characteristically scarred, calloused, and often missing tips from the machinery that could not be avoided when working at speed. The boys who were injured, or who fell into the chutes, could be carried into the machinery, and serious injuries were common. The mine owner's argument for employing breaker boys was that the work required nimble fingers and the ability to fit into the cramped spaces of the breaker structure, neither of which was true in any meaningful sense. The real argument was that boys were paid a fraction of what adult workers earned, that there was an essentially unlimited supply of them in the mining communities where alternative employment for children was non-existent, and that the work had always been done by boys and therefore seemed natural and inevitable. The glass industry employed children at night. Glass blowing required continuous operation to maintain the temperature of the furnaces, and the night shift was assigned to boys who carried molten glass between the furnaces and the blowers, working in temperatures that exceeded 100 degrees Fahrenheit throughout their shifts. The heat, the hours, and the physical demands of the work produced a distinctive set of health effects in glass workers, including premature aging, respiratory disease, and eye damage from the intense light of the molten glass. The canning industry employed children seasonally in facilities along the coasts where fish, oysters, and shrimp were processed, and inland where fruits and vegetables were canned during harvest season. The hours in canneries during the processing season were extraordinary. 16 or 18-hour days were common, with families, including children as young as 3 or 4 who were too small to work but too young to be left alone, spending those hours in the facilities. The children who were large enough to work were put to work. Heaney's photographs of the South Carolina shrimp canneries documented children working in the middle of the night, their faces blank with exhaustion, their hands raw from the salt water and the shells. The cannery operators argued that the seasonal nature of the work made it different from continuous factory employment, that the work was light, that the children were with their families. None of these arguments addressed the fundamental question of whether children as young as 5 should be working in industrial facilities at 4 in the morning. The street trades, newspaper selling, and bootblacking primarily employed boys in cities across the country in ways that were visible but less obviously industrial. Newsboys, who bought papers at wholesale and sold them at retail, keeping the difference, were nominally independent businessmen rather than employees. This classification exempted them from whatever minimal state regulations applied to factory workers and placed them entirely outside the framework of even the most basic child labor protections. The newsboy in practice worked long hours in all weather, competed aggressively with other newsboys for territory and customers, and was exposed to the full range of urban hazards, including traffic, crime, and the culture of the streets that reformers of the era considered corrupting. The romanticization of the newsboy as a plucky young entrepreneur was a cultural phenomenon that served the newspaper industry by obscuring the conditions under which these children actually worked. The reform movement that eventually produced federal child labor law developed over several decades, driven by a coalition of women's organizations, labor unions, social workers, and progressive politicians who documented conditions, organized public pressure, and pushed state by state and then federally for legislative change. Florence Kelley was one of the most important figures in this movement. Kelley had spent years in Hull House, Jane Addams's settlement house in Chicago, working directly with immigrant families in the industrial neighborhoods of the city. She had seen what factory work did to children, and she had concluded that voluntary reform by employers was not going to happen, and that state legislation, which could be evaded by moving work across state lines, was insufficient. Federal legislation was the only solution. Kelley became the General Secretary of the National Consumers League in 1899 and spent the next 3 decades building the political coalition that eventually produced federal child labor law. The strategy involved documenting conditions, producing public pressure through the documentation, winning state laws that created political momentum for federal action, and gradually building the congressional support needed for federal legislation. The state laws came first. By 1899, 28 states had some form of child labor legislation. though the laws varied enormously in their coverage and enforcement. Southern textile states had the weakest laws because the textile industry had the most political power in those states, and because the racial politics of the South meant that white mill workers' children were the primary focus of even the limited reform efforts. Black children working in agriculture were essentially unaddressed by any state child labor law. The National Child Labor Committee, founded in 1904, commissioned Lewis Hines' photographic documentation as part of a broader campaign to make the reality of child labor visible to middle-class Americans who had no direct contact with it. The photographs worked. They produced public outrage on a scale that was new because Hines' images were specific rather than statistical. The 5-year-old girl in the cannery had a name. The 8-year-old breaker boy had a face. The abstraction of child labor became concrete in ways that statistics never could. The first federal child labor law, the Keating-Owen Act of 1916, prohibited the interstate shipment of goods produced with child labor. Congress passed it under its Commerce Clause authority, regulating the movement of goods across state lines. The law was narrow but meaningful. It applied to manufacturing and mining. It set a minimum age of 14 for most work and 16 for mine work, and it limited the working hours of children between 14 and 16 to 8 hours per day. The Supreme Court struck it down in 1918 in Hammer v. Dagenhart. The court ruled 5-4 that the Commerce Clause did not give Congress the power to regulate the conditions of production that preceded the interstate shipment of goods. Congress could regulate commerce between states, but it could not use that power to regulate what happened inside a state's factories before the goods left the state. Justice Oliver Wendell Holmes wrote a famous dissent arguing that the majority's reasoning was incoherent, but he was one of 4. Congress immediately passed a second law, the Child Labor Tax Act of 1919, attempting to achieve the same result through Congress's taxing power rather than the commerce power. The law imposed a 10% tax on the profits of businesses that employed child labor. The Supreme Court struck that down too in Bailey v. Drexel Furniture in 1922, ruling that the tax was not a genuine revenue measure but a regulatory measure disguised as a tax. 2 federal laws, 2 Supreme Court decisions, both laws dead. The constitutional amendment approach was the next option. In 1924, Congress passed a proposed constitutional amendment giving Congress the power to regulate and prohibit the labor of persons under 18 years of age. It was sent to the states for ratification and failed. By 1938, only 28 of the required 36 states had ratified it. The opposition came from southern textile states, from agricultural interests who depended on child farm labor, and from a coalition of Catholic organizations that argued the amendment would give the federal government excessive authority over family decisions about children's work. The failure of the amendment left federal child labor law legally impossible under the constitutional doctrine of the era. What changed everything was the Great Depression. When unemployment hit 25% in the early 1930s, the political argument against child labor changed fundamentally. Before the Depression, the argument for child labor was economic necessity. Poor families needed the income that their children's work provided, and removing that income would cause genuine hardship. This argument had real force because it was true that many poor families depended on children's earnings. After the Depression began, the argument against child labor became economic necessity of a different kind. Children in the workforce were taking jobs that unemployed adults needed. A 14-year-old working in a textile mill was a job that an adult head of household was not working. In a labor market with 25% unemployment, that was a political argument that resonated in ways that humanitarian arguments about children's welfare had not. The Fair Labor Standards Act of 1938 addressed this new political reality. The act established a federal minimum wage, a maximum work week of 40 hours for interstate commerce, and restrictions on child labor. The child labor provisions set a minimum age of 16 for most employment, 18 for hazardous occupations, and 14 for certain light work outside school hours. Agriculture was largely exempted, a concession to Southern agricultural interests that was the price of getting the act passed. The Supreme Court upheld the Fair Labor Standards Act in United States v. Darby in 1941, explicitly overruling Hammer v. Dagenhart and acknowledging that the Commerce Clause gave Congress the authority to regulate the conditions of production, not just the act of interstate shipment. The constitutional doctrine that had blocked child labor law for 22 years was gone. The impact of the Fair Labor Standards Act on child labor was immediate and significant. The number of children in industrial employment fell sharply in the years following the Act's passage, not because all employers immediately complied, but because the federal enforcement mechanism provided for the first time a legal basis for action against the worst violators. But the agricultural exemption meant that the children who were most severely exploited by child labor, the children of migrant farm workers who followed the harvests across the country, picking fruits and vegetables in conditions that were in many cases worse than anything in the industrial sector, received no federal protection. The Fair Labor Standards Act protected children in factories. It did not protect children in fields. This exemption was not an oversight. It was a deliberate concession to Southern agricultural interests and to the racial politics that made the protection of Black and Latino farm workers politically impossible in 1938. The children working in the fields were disproportionately Black in the South and increasingly Latino in the West and Southwest, and their exclusion from the law's coverage reflected the same racial dynamic that had excluded agricultural workers from Social Security 3 years earlier. The agricultural exemption has never been fully corrected. Under current federal law, children as young as 12 can work on farms with their parents' consent, and children as young as 14 can work on any farm outside school hours. These minimum ages are significantly lower than the 16-year minimum that applies to non-agricultural work. Children on small farms are subject to no federal age restrictions at all, and the hazardous occupation restrictions that apply to industrial child workers do not apply with the same force to farm workers under 18. Agriculture is the most dangerous industry in the United States for children. Children working in agriculture suffer fatal injury rates approximately 4 times higher than children working in other industries. They work with heavy machinery, with pesticides that are not labeled for exposure to minors, in heat conditions that have killed child agricultural workers in recent years. They are disproportionately Latino and often undocumented, or the children of undocumented workers, which limits their practical ability to assert even the limited legal rights they have. The history of child labor in America did not end in 1938. The Fair Labor Standards Act was a genuine achievement that removed most children from most industrial employment. It was not comprehensive, it exempted the most vulnerable workers, and its enforcement has been inconsistent in the decades since its passage. The contemporary child labor problem in America has 2 distinct dimensions. The first is the agricultural dimension, the ongoing employment of children in farm work under the permissive standards that have never been reformed since 1938. The second is a more recent phenomenon that has received significant investigative journalism attention in the past several years: the employment of undocumented migrant children in industrial settings that are clearly covered by the Fair Labor Standards Act, and that are clearly illegal under its provisions. Investigative reporting by the New York Times and the Department of Labor's own enforcement actions have documented in recent years the employment of children as young as 12 and 13 in poultry processing plants, in meatpacking facilities, in construction, in roofing, in auto parts manufacturing. These children are working in exactly the kinds of hazardous industrial settings that the 1938 Act was designed to prohibit. They are working because they are undocumented minors who have been separated from their families and are being exploited by labor contractors and employers who know that these children have essentially no practical recourse. The Department of Labor's child labor enforcement actions increased significantly in 2022 and 2023, with investigations finding child labor violations in industries including food manufacturing, construction, and sanitation. The violations found were not marginal cases. They included children working overnight shifts in food processing facilities, children operating dangerous machinery, children in roofing who had been injured in falls. The political response to these findings has been contradictory. At the federal level, there have been calls for increased enforcement funding and stronger penalties. At the state level, the response has been different. Multiple states passed or considered legislation in 2022 and 2023 that weakened child labor protections, allowing younger children to work longer hours in a broader range of jobs. Arkansas, Iowa, New Hampshire, New Jersey, and several other states moved in this direction, with proponents arguing that reducing restrictions would help address labor shortages and give young workers more economic opportunity. The argument that weakening child labor protections is a response to labor shortages is the same argument, in a different form, that was used to justify child labor in the early 20th century. Economic necessity requires that children work, and legal restrictions on their work impose costs that the economy cannot afford. The argument was wrong in 1900. It is wrong in 2025. What the state-level rollbacks actually produce is cheaper labor for employers, not better outcomes for children. The children who benefit most from weak child labor protections are not teenagers who want to work a few extra hours at a summer job. They are the children of poor families who need their children's income, in an echo of the Milltown families of the early 20th century, and undocumented children who have no alternative and who are exploited by employers who know it. Lewis Hines' photographs are more than a century old. The 5-year-old girl in the South Carolina cannery, the 8-year-old breaker boy in the Pennsylvania coal mine, the 12-year-old girl standing on a box to reach the power loom. These children are long dead, and the specific industries that employed them in those conditions have been transformed beyond recognition. But the dynamic that produced their exploitation, in which the cost of labor is minimized by employing workers who have the least power to resist exploitation, who have the fewest legal protections, who are the most economically vulnerable, who are the most easily intimidated, has not been eliminated. It has found new populations to exploit, in the undocumented migrant children working overnight in poultry plants, in the children of agricultural workers picking strawberries in the heat, in the teenagers in states that have rolled back protections working hours that interfere with their education and their development. The Fair Labor Standards Act of 1938 was a genuine achievement. It removed millions of children from industrial employment that was harmful to their health and their development. It established the principle that the federal government had both the authority and the obligation to set minimum standards for child labor, regardless of what individual states chose to allow. That principle is worth preserving. And understanding how hard it was to establish, how many decades it took, how many children were harmed in the decades it took, is the foundation for understanding why preserving it matters. From the breaker boys of 1900 to the undocumented children in the poultry plants of 2023. From Lewis Hines photographs to the Department of Labor's enforcement actions. From the Keating-Owen Act struck down in 1918 to the Fair Labor Standards Act upheld in 1941. The history is longer than most people know, and it is not finished. Subscribe if this is the kind of history you are here for. There is a great deal more of it ahead. To understand why child labor persisted for as long as it did in America, you need to understand the specific economic and social structures that made it not just possible, but actively encouraged. And you need to understand why the arguments against reform were as powerful as they were for as long as they were. The foundational argument for child labor in the industrial era was not that children were unharmed by it. Everyone could see that the work was hard, that the hours were long, that the conditions were dangerous. The argument was that the alternative was worse. Poor families needed the income that their children's work provided. Without it, they would face poverty more severe than any harm the work itself caused. This argument was made sincerely by some of its proponents and cynically by others, but its sincerity or cynicism was less important than its political effectiveness. The argument had real force because it was partially true. The poorest families in industrial America did depend on their children's earnings. A family of 5 living in a mill town on a single adult male's wages, in an era before minimum wage laws, before unemployment insurance, before food assistance programs of any kind, faced genuine destitution if the children did not contribute to the household income. The choice for some families was not between child labor and comfortable childhood. It was between child labor and hunger. What the argument obscured was that this dependency was itself a product of the economic structure that the same employers who employed the children had helped create. Wages for adult workers were kept low, partly because the availability of child labor at lower wages gave employers a credible alternative to paying adults more. The poverty that made families dependent on children's wages was partly a product of the same system that employed those children. The dependency was not a natural fact that child labor regulation would worsen. It was a structural condition that adequate adult wages and other labor protections would have alleviated. The reformers who understood this made the argument, repeatedly and with evidence. Florence Kelley had documented in her work in Chicago that families in industries where child labor had been eliminated or restricted were not worse off than families in industries where it continued. Where adult wages were higher, as they tended to be in industries that did not compete with child labor, family income was sufficient to support children in school rather than in the workforce. The dependency on child income was not inevitable, it was manufactured. But the manufactured nature of the dependency was difficult to communicate to families living inside it. A family that was actually dependent on its children's earnings could not be persuaded by abstract arguments about economic structures. It needed the immediate income to survive the immediate month. The reform argument required a level of trust in the long-term improvement that the immediate-term sacrifice would produce. And the trust was not easy to establish in communities that had experienced repeated disappointments from political promises. This dynamic between the immediate economic reality of poor families and the structural economic argument of reformers is one of the reasons that child labor reform took as long as it did. The families that were most harmed by child labor were in many cases also the families that were most resistant to laws eliminating it, because the laws would have removed an income source before anything had replaced it. The political economy of child labor reform was complicated in another way. The industries that employed children were politically powerful, and they used that power aggressively to resist regulation. The southern textile industry is the clearest example. The mills of the Carolina Piedmont and the Georgia Hills were the economic foundation of the communities they occupied. The mill owners were the most important employers, the largest taxpayers, the most significant donors to political campaigns in their counties and states. State legislators who represented textile districts knew that their political survival depended on their relationship with the mills, and the mills were unambiguously opposed to child labor legislation. The mills made their opposition politically effective through a combination of economic argument and racial politics. The economic argument was straightforward. Child labor restrictions would raise production costs, reduce competitiveness, and potentially drive mills to close, taking with them the adult employment and the community infrastructure that the mills supported. The racial argument was more complex and more insidious. The reformers who were advocating for child labor restrictions were Northern women who did not understand Southern conditions, who were imposing Northern values on Southern communities, and whose real agenda was racial rather than humanitarian. The racial argument was effective because the reform movement was indeed largely Northern and largely white, and because it focused primarily on white children in industrial settings, while largely ignoring the conditions of black children in agricultural labor. This inconsistency, which reflected the racial limits of the reform movement rather than any racial agenda, was nonetheless used by Southern mill owners to paint the reform effort as hypocritical and externally imposed. The Catholic Church's opposition to the 1924 constitutional amendment deserves specific attention because it has been historically underappreciated in accounts of why the amendment failed. The National Catholic Welfare Conference, which coordinated Catholic political activity, opposed the amendment on the grounds that it gave the federal government authority over persons under 18 that properly belonged to families and to the Church. The argument was framed in terms of parental rights and religious liberty, but its practical effect was to align the Catholic Church with the industrial interests that were the amendment's primary opponents. Catholic opposition was politically significant because the Democratic Party, which was the vehicle for most progressive labor legislation of the era, relied heavily on Catholic voters in northern cities. Having the Catholic hierarchy opposed to child labor legislation made it politically more complicated for Democratic politicians to support it without fracturing their own coalition. The failure of the amendment to ratify in Catholic-heavy states like Connecticut and New York was directly traceable to this opposition. The constitutional barrier that the Supreme Court constructed in Hammer v. Dagenhart was the most significant single obstacle to federal child labor legislation. The decision was not intellectually coherent, as Holmes's dissent made clear, but its effect was to remove from Congress the tools it needed to act. The years between 1918 and 1938, during which federal child labor law was constitutionally impossible, were years during which conditions in many industries improved somewhat as public pressure produced state-level reform, but during which the children in the most exploitative situations, in the states with the weakest reform traditions, continued to work under conditions that the federal government could not address. The Great Depression's role in making the Fair Labor Standards Act possible is well documented but often misunderstood. The Depression did not produce a sudden conversion of conservative politicians to progressive labor standards. It produced a specific political argument that children in the workforce were taking jobs from unemployed adults that conservative politicians could accept without accepting the underlying progressive argument about children's rights and welfare. This is worth dwelling on because it illustrates a pattern that recurs throughout the history of American labor legislation. The political arguments that succeed are often not the moral arguments. They are the economic arguments that align with the interests of a sufficient political coalition. The moral argument against child labor, that it harmed children, that it deprived them of education, that it damaged their development, had been made for decades without producing federal legislation. The economic argument that children were displacing adult workers produced legislation within a decade. The Fair Labor Standards Act of 1938 was itself the product of a political compromise that reflected the limits of what was achievable. The agricultural exemption was the price of Southern support. The exemption for certain light work by 14 and 15-year-olds outside school hours was the price of employers in the service sector who had organized minor employment programs. The specific age thresholds were products of negotiation rather than careful assessment of what ages were actually safe for various types of work. These compromises produced a law that was more effective than anything that had previously existed, but that left significant gaps. The agricultural exemption was the largest, but it was not the only one. Domestic service was initially exempted. Workers in very small establishments were exempted. The definition of hazardous work that justified the 18-year minimum was incomplete and has required regular updating as new hazards have been identified. The enforcement of the Fair Labor Standards Act's child labor provisions has also been inconsistent over time. The Department of Labor's Wage and Hour Division, which enforces the child labor provisions along with wage and hour standards, is chronically underfunded relative to the scope of its enforcement responsibility. The number of wage and hour investigators has not kept pace with the growth of the covered workforce, and the penalty structure for child labor violations is insufficient to deter large employers for whom the fines are a minor operating cost. The recent investigations that found undocumented minors working in industrial settings covered by the Act represent a specific enforcement failure. Employers who know that their workers have limited ability to report violations and limited access to legal recourse can calculate that the probability of enforcement action multiplied by the likely penalty is smaller than the labor cost savings from employing children at lower wages. The calculation works out the same way it worked out for the mill owners of the early 20th century. The only thing that changes is the specific population being exploited. What is required to break this calculation is higher penalties, more inspectors, and an enforcement approach that targets not just the immediate employer of record, but the entire supply chain that benefits from the child labor. A food company that contracts with a staffing agency that employs undocumented minors in a processing facility has benefited from that child labor, even if the immediate employment relationship is with the staffing agency. Extending liability through the supply chain, as some recent legislative proposals have sought to do, would change the calculation by expanding the universe of parties who face legal risk. The argument against these reforms sounds familiar, because it is the same argument that has been made against every child labor reform for more than a century. The costs are too high, the regulations are too burdensome, the market will correct the problem if given time. The proposed reforms misunderstand the economic realities facing the affected industries. The market did not correct the problem between 1900 and 1938. It will not correct the problem now. The exploitation of children in the labor market is a structural feature of systems in which some workers have less power than others, and it requires structural responses in the form of law and enforcement. That is what the history of child labor in America shows, from the 5-year-old girl in Lewis Hines' photograph to the 12-year-old in the contemporary Department of Labor enforcement action. The specific children change. The specific industries change. The fundamental dynamic in which the least powerful workers are the most exploited does not change without deliberate, sustained, legally enforced intervention. Understanding that history is the beginning of understanding why the intervention is necessary and what it requires. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. There is one more dimension of this history that deserves careful attention because it connects the documented past to the disputed present in ways that the historical record makes clear. That dimension is the role of education in the child labor debate, and specifically the relationship between child labor and the development of compulsory public education in America. The two movements developed in parallel and in tension with each other throughout the late 19th and early 20th centuries. Compulsory education laws, which required children to attend school up to a certain age, were passed by states beginning in the 1850s and were in place in most northern states by the 1880s. These laws created a direct conflict with child labor in the industries that employed children during school hours because a child who was required by law to be in school could not simultaneously be working in a factory. The industries that employed children responded to compulsory education laws in several ways. Some simply ignored them, relying on the inadequacy of enforcement. Some lobbied for exemptions that permitted children to work when their families could demonstrate economic need. Some located operations in states or counties where compulsory education was less rigorously enforced, and some made a more direct political argument that compulsory education was itself a form of government overreach that interfered with family autonomy and economic necessity. This argument sounds familiar in 2025 because it is being made again. Several of the state-level rollbacks of child labor protections that occurred in 2022 and 2023 were explicitly framed in terms of student autonomy and the right of teenagers to work. The proponents argued that existing restrictions prevented young people who wanted to work from doing so, and that reducing these restrictions would give them greater economic opportunity. The argument conflates two very different situations. A 17-year-old who wants to work part-time during the school year, in a safe job that does not interfere with their education, is in a fundamentally different situation from a 15-year-old who is working 40 hours a week in a meatpacking plant because their family needs the income. The existing restrictions are calibrated, imperfectly but deliberately, to allow the former while prohibiting the latter. The rollbacks loosen the restrictions in ways that potentially permit both. The connection to education is not incidental. The children who are most harmed by child labor are those whose work interferes with their education, because the harm of reduced education accumulates over a lifetime in reduced earnings, reduced economic mobility, and reduced access to the opportunities that education provides. The studies of children who left school early to work in industrial settings in the early 20th century show systematically worse outcomes across the life course, exactly as the reformers predicted. The children who work in agriculture today, who follow harvests across the country and attend school irregularly as a result, experience exactly this pattern. Their educational attainment is significantly lower than children in non-agricultural settings. Their earnings as adults are significantly lower. Their economic mobility across generations is significantly more limited. The agricultural exemption from child labor law is not merely a failure to protect children from dangerous work in the present. It is a mechanism that reproduces poverty across generations by limiting the educational attainment of the children it fails to protect. This is the argument that Lewis Hine was making with his photographs, though he could not have expressed it in these terms. The 5-year-old girl in the South Carolina cannery was not just being exposed to physical danger. She was being denied the education that would have given her options that the cannery would not. The decision to send her to the cannery at 5 instead of to school was a decision that would constrain her economic options for the rest of her life, and that her children would likely inherit. Understanding child labor as an educational issue rather than purely as a labor issue changes the stakes of the debate. It moves the question from whether children are being harmed today to whether they are being positioned for a lifetime of limited opportunity. The harm is not just in the injury risk of the specific job. It is in the educational deprivation that results from time spent working instead of learning. The current debate about child labor protections, both at the federal level in the context of enforcement against undocumented minors in industrial settings and at the state level in the context of legislative rollbacks, needs to be understood in this fuller context. It is not just a debate about whether children are exposed to dangerous conditions. It is a debate about the distribution of economic opportunity across generations, about which children will have access to education that gives them options and which children will have access only to the kind of work that Lewis Hine photographed in 1908. The answer that America gave to that question in 1938, after 4 decades of political failure, was that the federal government had both the authority and the obligation to set minimum standards that protected children from exploitation regardless of their family's economic situation or their employer's preferences. That answer is being challenged again, in ways that are less visible and less dramatic than the mill towns and mine shafts of the early 20th century, but that are no less consequential for the children affected. The breaker boys of Pennsylvania and the cannery children of South Carolina could not advocate for themselves. They had no vote, no political voice, no legal standing to contest the conditions of their employment. Their advocacy was done by people like Lewis Hine and Florence Kelley and the members of the National Child Labor Committee, who saw what was happening and decided that making it visible and politically costly was their responsibility. The undocumented migrant children working in contemporary American poultry plants and construction sites are in a comparable position. They have even less ability to advocate for themselves than the breaker boys did, because their immigration status adds a layer of vulnerability that the breaker boys did not face. Their advocacy, to the extent it exists, is being done by labor enforcement agencies that are underfunded, by investigative journalists who document what the agencies miss, and by immigration advocacy organizations that are fighting on multiple fronts simultaneously. Whether that advocacy will be sufficient to produce the kind of political response that Lewis Hine's photographs eventually produced is uncertain. The political environment is different. The visibility of the problem is lower because the children affected are less visible to the majority of the American public. The political coalitions that would need to mobilize for reform are more fragmented than the coalition that produced the Fair Labor Standards Act. But the history of child labor in America suggests that political impossibility has a way of becoming political necessity when the evidence of harm becomes sufficiently undeniable. The Fair Labor Standards Act was politically impossible in 1900, in 1910, in 1920, and in 1930. It passed in 1938. Not because the moral argument had changed, but because the political conditions had finally aligned in ways that made action possible. The moral argument has not changed. Children should not be exploited for the economic benefit of their employers. The education and development of children should not be sacrificed for the labor cost savings of the industries that employ them. The most vulnerable children should have at least the same legal protections as the least vulnerable ones. That argument was made by Florence Kelley in 1899. It was made by Lewis Hine's photographs between 1908 and 1916. It was made by the members of Congress who passed the Keating-Owen Act in 1916 and watched the Supreme Court strike it down. It was made again by the Congress that passed the Fair Labor Standards Act in 1938. It is being made now by the enforcement attorneys at the Department of Labor who are pursuing cases against employers of undocumented migrant children, by the investigative journalists who are documenting what the enforcement attorneys cannot reach, and by the advocates who are fighting the state-level rollbacks that are moving in the wrong direction, from Lewis Hine's photographs to the Department of Labor's enforcement actions, from the Breaker Boys of 1908 to the poultry plant workers of 2023, from the Keating-Owen Act struck down in 1918 to the state rollbacks passed in 2023. The history is longer than most people know, the struggle is older than the law that partially addressed it, and the work is not finished. Subscribe if this kind of history is what you are here for. There is more ahead. The international context of American child labor history is worth understanding briefly, because the comparison with other industrialized countries illuminates both how late America was in addressing the problem and how the American approach differed from the approaches taken elsewhere. Britain, which industrialized before the United States and which therefore encountered the child labor problem first, began regulating factory child labor in 1833 with the Factory Act, which set minimum ages and maximum hours for children in textile mills. Subsequent factory acts in 1844, 1847, and 1867 progressively tightened the restrictions and extended them to additional industries. By 1870, Britain had a system of factory inspection, compulsory school attendance, and child labor restrictions that was more comprehensive than anything in the United States. Germany, under Bismarck, regulated child labor in factories beginning in 1878, setting a minimum age of 12 for factory work and 14 for mine work. The German approach, as with its approach to old age insurance, reflected the view that the state had legitimate interests in the welfare of workers and their children that overrode the claims of employers to manage their workforces without interference. The United States, with its stronger tradition of states' rights, its weaker labor movement, its more powerful industrial lobby, and its more adversarial constitutional framework, lagged behind both Britain and Germany by decades. The constitutional barriers that the Supreme Court erected in Hammer v. Dagenhart had no equivalent in British or German constitutional law, because neither system gave courts the power to strike down legislation as readily as the American system did. The lag had consequences that went beyond the immediate harm to children who were employed during the years when federal regulation was blocked. The industries that were built on child labor, the southern textile industry in particular, developed business models, wage structures, and production practices that assumed the availability of cheap child labor. When child labor was finally restricted, these industries did not immediately restructure to pay higher adult wages. Many of them relocated operations to other countries where labor costs were lower, beginning a pattern of industrial flight from labor regulation that has continued in various forms to the present day. This pattern, in which labor regulation produces industrial relocation rather than industrial improvement, is the outcome that opponents of child labor regulation predicted and that proponents argued would not occur. The reality was more complicated than either side's prediction. Some industries did leave, others found ways to maintain competitiveness through productivity, improvement, and technology adoption. The net effect on employment was not the catastrophic job loss that opponents predicted, but neither was it the painless transition that proponents sometimes suggested. The current debate about child labor protections in the context of the broader debate about labor regulation and international competitiveness echoes this history. Industries that argue for weaker child labor protections on the grounds that stronger protections make them uncompetitive are making the same argument that the textile mills made in the 1930s. The argument has more force in some sectors than others, but its logic points toward a race to the bottom in which the country with the weakest protections attracts the industries that benefit most from exploiting vulnerable workers. The international response to this dynamic has been the development of international labor standards through the International Labor Organization, which has produced conventions on child labor that most developed countries have ratified. The United States has ratified 2 of the ILO's core child labor conventions, prohibiting the worst forms of child labor. Its record on implementing those conventions domestically is stronger than its record on agricultural child labor would suggest. The worst forms of child labor convention, which the United States ratified in 1999, commit signatory countries to prohibit the use of children in hazardous work and enforce labor. The undocumented migrant children working in American poultry plants and construction sites are arguably working in conditions that violate the spirit, if not the letter, of these commitments, though the legal analysis is complicated by the domestic implementation of the convention's requirements. What is not complicated is the history. The United States took 162 years from its founding to establish federal minimum age requirements for industrial child labor. It took those 162 years, despite the availability of evidence, documented with precision by Lewis Hine and others, that the work was harmful to children's health and development. It took those 162 years, despite the passage of 2 federal laws that were struck down by the courts, despite the failure of a constitutional amendment, despite decades of state-level reform that left the most exploited children in the least reformed states. The 162 years were not years of ignorance. They were years of political choice. The choice to prioritize industrial production over children's welfare was made, repeatedly and with awareness of the consequences, by political systems that were more responsive to the interests of industrial employers than to the interests of the children who worked for them. The Fair Labor Standards Act of 1938 represented a change in that political calculus, produced by the specific conditions of the Depression rather than by any fundamental change in the underlying power relationships. The agricultural exemption that accompanied the act showed the limits of how far the change extended. The children who were least powerful, who worked for the least powerful employers, who had the least access to the political process, were left out of the reforms that covered everyone else. That pattern persists. The children who are most at risk from child labor in 2025 are the children who were least protected in 1938: agricultural workers, undocumented workers, children in the informal economy. The formal legal protections that cover most American children are real and meaningful. The gaps in those protections are also real and meaningful, and they fall on the same populations that have always been in the gaps. Understanding that continuity is the beginning of understanding what it would take to close the gaps that remain. It would take the same thing that closing the gaps in 1938 took: sufficient political pressure from sufficient political constituencies, sustained over sufficient time, to overcome the opposition of the industries that benefit from the gaps. The Breaker Boys of Pennsylvania and the 5-year-old girl in the South Carolina cannery waited 62 years for Lewis Hine to document their conditions and 30 years more for federal law to change them. The children who are working in the gaps today should not have to wait that long. That is the history of child labor in America, and it is not finished. Subscribe if this is the kind of history you are here for. There is more ahead. There is one final thread that connects this history directly to every person watching this video who has ever had a job, who has children who will have jobs, or who pays taxes that fund the enforcement agencies responsible for making sure the jobs people have are legal. That thread is the question of what child labor law is actually for, not in the abstract sense of its stated purpose, but in the concrete sense of what values it embodies and what kind of society it is trying to create. The argument for child labor, in every era in which it has been made, has rested on a conception of children as economic units whose labor is legitimately available to whoever can employ it, subject only to whatever the market will bear. In this conception, a child's time and physical capacity are resources that belong to the family and can be deployed as the family sees fit, including by selling that time and capacity to an employer. The state's interest in restricting this is limited because the transaction is voluntary and the family is best positioned to assess its own needs. The argument against child labor rests on a different conception of children. As developing people whose development the society has a collective interest in protecting, because the kind of adults they become affects everyone, not just their families. In this conception, a child's time during the years of education and development is not simply a family resource to be deployed as the family chooses. It is something in which the society as a whole has an investment, because an educated, healthy adult workforce is a public good, and an exploited, uneducated one is a public burden. These two conceptions of children and of the state's interest in their welfare have been in tension throughout American history. The Fair Labor Standards Act of 1938 represented a decisive, if incomplete, victory for the second conception. The state, through federal law, asserted the authority to set minimum conditions for children's employment over the objections of employers who preferred the first conception. The state-level rollbacks of 2022 and 2023 represent a partial reassertion of the first conception. The argument that teenagers should have the right to work more hours in more dangerous conditions is an argument that treats the child's labor as primarily a family resource rather than as something in which the society has a stake. It is not, in its stated form, an argument for child exploitation. But its practical effect, in the context of a labor market where some children have no practical alternative to working in dangerous conditions, is to make exploitation easier. The people who made child labor possible in the early 20th century did not think of themselves as exploiters either. The mill owners believed, or claimed to believe, that they were providing economic opportunity to poor families who would otherwise have nothing. The coal operators believed they were employing boys in honest work that built character. The cannery operators believed the seasonal work was light and the children were with their families. None of those beliefs, sincere or claimed, changed what was happening to the children. The 5-year-old girl in Lewis Hine's photograph was working in conditions that harmed her, regardless of what the cannery operator believed about those conditions. The 8-year-old breaker boy was breathing coal dust that would damage his lungs, regardless of what the mine operator said about the character-building properties of honest labor. What changed the situation was not a change in the beliefs of employers. It was a change in the law. The Fair Labor Standards Act did not persuade mill owners that child labor was wrong. It made it illegal, and it provided enforcement mechanisms that made illegal conduct costly. The change in employer behavior that followed was a response to the legal change, not to a change in moral conviction. This is the lesson that the history of child labor in America most clearly teaches. Voluntary reform is not sufficient. Public awareness is not sufficient. Moral suasion is not sufficient. What produces change in the conditions of the most vulnerable workers is law, and law that is adequately funded and enforced. The people who made the Fair Labor Standards Act possible understood this. Florence Kelley understood it. The members of Congress who passed the Keating-Owen Act in 1916 and then passed it again in 1938 after the Supreme Court had changed understood it. The progressive politicians of New York who spent 4 years after the Triangle Fire passing 56 pieces of legislation understood it. The people who are fighting the current rollbacks and the current enforcement failures understand it too. What they need, as the reformers of the early 20th century needed, is sufficient political support to make the understanding matter. That support comes from the people who know the history, who understand what child labor actually looks like when it is unregulated, and who are willing to demand that the legal protections that were established with such difficulty are maintained and extended rather than eroded. You now know that history. From Lewis Hine's camera in 1908 to the Department of Labor's enforcement actions in 2023. From the 5-year-old girl in the South Carolina cannery to the 12-year-old in the contemporary poultry plant. From Hammer versus Dagenhart in 1918 to the state rollbacks of 2022 and 2023. The history is not finished. The next chapter is being written now. Subscribe if you want to keep following it. There is more ahead.